We welcome you all in the second session of the day titled Developing an Institutional Culture for Effective Mediation in Courts. Ladies and gentlemen, please put your hands together to welcome our honorable panelists and moderators on the stage in this session. We are privileged to have on this panel Honorable Judge, Supreme Court of India, Mr. Justice S. Ravindra Bhatt. Please welcome Honorable Mr. Justice S. Ravindra Bhatt. Also, we have Mr. Justice N. Koteshwar Singh, Chief Justice, Jammu Kashmir and Ladakh High Court, who has come here to attend this session, and Mr. Shriram Panchu, Senior Advocate and Mediator. They are as panelists on the stage, and for this session, our moderators are Mr. Justice Sanjeev Sachdeva, Judge, Delhi High Court and Member, Overseeing Committee Samadhan, and Mr. Sudhanshu Batra, Senior Advocate. आइए एक बार सबका हम स्वागत करें आपकी करतल ध्वनि के साथ with a huge round of applause. Ladies and gentlemen, please welcome all the dignitaries, all the panelists and moderators on the stage. And to do the honors, first of all, I will request Justice Nina Krishna Bansal. She is
हेलो 8 माइक है 8 सर 8 माइक है
I will request Mr. Justice Naveen Chawla to felicitate, to welcome Mr. Justice S. Ravindra Bhatt on the stage. We are honored to have Honorable Mr. Justice S. Ravindra Bhatt, Judge, Supreme Court of India, in this panel, and we welcome him with a plant. Justice Naveen Chawla.
Thank you.
Now I will request Justice Saurabh Banerjee, Judge, Delhi High Court, to please come on stage and do the honors. Mr. Justice N. Koteshwar Singh, Chief Justice, Jammu Kashmir and Ladakh High Court. No? I will invite Justice Sudhir Kumar Jain, Mr. Justice Sudhir Kumar Jain, Judge, Delhi High Court, to felicitate, to do the honors, Mr. Justice N. Koteshwar Singh, Chief Justice, Jammu and Kashmir and Ladakh High Court. He is with us in this panel, in this session.
Thank you so much. Thank you very much.
And now I will invite on stage Aditi Chaudhary ma'am, who is Director, Delhi Judicial Academy, to welcome and felicitate Mr. Shriram Panchu, Senior Advocate and Mediator, who is part of this panel and who has come here to attend this session. We welcome Mr. Shriram Panchu. Thank you very much, sir. We welcome all of you. Ladies and gentlemen, in the due course, the panelists will be introduced by the moderators. But let me introduce the moderators first. Honorable Mr. Justice Sanjeev Sachdeva, Judge, Delhi High Court. Justice Sachdeva was enrolled as an advocate with the Bar Council of Delhi in the year 1988. He attended the Commonwealth Young Lawyers course in 1992 from University of London and worked with solicitors and barristers in England as part of the said course. He qualified as an advocate on record of the Supreme Court of India in June 1995. As a lead trainer, he has imparted training to advocates from various high courts in advocacy skills. He was awarded the British Council Scholarship to be one of the 5 young lawyers to represent India at the Commonwealth Young Lawyers course in 1992 at the University of London. He was elevated as an additional judge of Delhi High Court in 2013 and became permanent judge on 18th March 2015. As a lawyer, he was associated with Samadhan as a trainee, and now he is a member of Overseeing Committee Samadhan. और कल मोबाइल ऐप जो लॉन्च हुआ उसकी जो आवाज़ आपने सुनी उसमें वॉइस ओवर के रूप में वो भी ऑनरेबल मिस्टर जस्टिस संजीव सचदेवा जी की ही थी. ही इज सच अ क्रिएटिव पर्सन and he is guiding us regularly in this field. Our second moderator in this session is Mr. Sudhanshu Batra. Sudhanshu Batra ji is a practicing senior advocate and a trained mediator. He is a former organizing secretary of the Delhi High Court Mediation Center Samadhan. He received his basic and advanced training in mediation at Delhi, then completed the Train the Trainer TOT program from the University of Utah, USA. Besides having conducted hundreds of private and court annexed mediations, he has trained lawyers of several high courts, district courts, consumer courts across the country, as well as judicial officers at Delhi, Chandigarh, Bangalore, and Rajasthan. He has been appointed as an observer by the Mediation and Conciliation Project Committee of the Honorable Supreme Court of India. Mr. Batra is a member of the Organizing Committee of Delhi High Court Mediation and Conciliation Center and also impaneled as a mediator with the Samadhan, Singapore International Mediation Center, and a private mediation center, Camp Bangalore. With this introduction, let's welcome all the dignitaries on the stage, and I will request Honorable Mr. Justice Sanjeev Sachdeva to initiate the proceedings of this session. Mike, please.
All right. It is indeed my privilege to welcome Justice Ravindra Bhatt. I'd like to introduce him, though he does not need any introduction amongst the August gathering. He was born on 21st October 1958 in Mysore, Karnataka. Studied in Bangalore and Gwalior and completed his schooling from Kendriya Vidyalaya, Faridabad. Did BA Honours in English from Hindu College, University of Delhi, and obtained his LLB degree from Campus Law Centre, Faculty of Law, University of Delhi in 1982. He also enrolled as an advocate with the Bar Council of Delhi in 1982 and practiced in the Supreme Court, where he was enrolled as an advocate on record in 1989. He practiced in public law, employment, education, and constitutional disputes, and appeared in several important cases before the constitution benches of the Supreme Court during his legal career. He was appointed as a judge of the Delhi High Court on 16 July 2004, and then took over as Chief Justice of the High Court of Rajasthan on 5th May 2019, and has been elevated as a judge of the Supreme Court on 23rd September 2019. It is also a pleasure to introduce Justice N. Koteshwar Singh, who was born on 1st March 1963 at Imphal, Manipur. Justice Koteshwar Singh is the second in line as a judge of a high court, his father also being a judge of the Guwahati High Court. He's completed his schooling from Puralia, West Bengal, and did his pre-university course in science from St. Anthony College, Shillong. Did his graduation from the Delhi University in BA Honours in 1983 and obtained his degree in law again from Campus Law Centre, University of Delhi in 1986, and thereafter enrolled as an advocate in 1986. Justice Singh received a Commonwealth scholarship to be one of the five young lawyers from India to attend the Commonwealth Young Lawyers course, along with 20 lawyers from Commonwealth countries. Incidentally, 3 of us in this hall were part of that course: Justice Koteshwar Singh, Justice Alexander Thomas, Judge Kerala High Court, and myself. One of the sessions taught there was alternative dispute resolution in mechanism in negotiation and settlement. After practicing briefly before the Supreme Court, Justice Singh shifted his practice to Guwahati High Court, where he served as the Advocate General for the state of Manipur from 2007 and was designated as a senior advocate in 2008. Justice Koteshwar Singh was elevated to the bench as the judge of the Guwahati High Court on 17/10/2011, and he also performed the duties of Chief Justice of Manipur and as acting Chief Justice of Guwahati High Court. He was sworn in as the 36th Chief Justice of Jammu and Kashmir and Ladakh High Court on 15/2/2003. We welcome you, sir, as part of the panel.
Thank you, Justice Sachdeva. Mr. Sriram Panchu, the third expert on our panel today. Mr. Panchu is a senior advocate of 46 years of standing at the bar. For almost 30 years, he has been in the forefront of mediation movement in India and is an internationally recognized Indian mediator. He's the alumnus of the Government College Law, Bombay. He commenced practice in 1976 at the Madras High Court and was designated as a senior advocate in 1996. His field of law practice is constitutional and commercial law. He has appeared pro bono in several significant public causes before the Supreme Court and the High Courts. In 2005, he was instrumental in setting up India's first court-annexed mediation center at the Madras High Court and has assisted the Supreme Court and other high courts to do so. He has trained over 1,000 mediators. His books on mediation are Settled for More in 2007, Mediation Practice and Law 2011, 2015, and then 2022, and the Commercial Mediation Monograph 2019. He has mediated a large number of complex and high-value commercial disputes in India and abroad. He has also mediated significant family disputes, including inheritance and family business disputes. He has been appointed by the Supreme Court of India to mediate significant public disputes. This includes a major border dispute between the states of Assam and Nagaland, and a dispute within the Parsi community in Bombay over a ban on priests. In March 2019, he was appointed on a 3-member panel to mediate the Ayodhya Ram Janmabhoomi Babri Masjid dispute. In December 2018, the Bar Association of India conferred on him its Lawyers of India Day Award of Honor and Distinction. Mr. Panchu has served on the National Legal Services Authority of India, NALSA, and was the first president of the National Association Mediators in India. He was also director of the International Mediation Institute, IMI, The Hague. He is on the panel of senior mediators of national and international institutions. He serves on the committees of several public charitable and social organizations. We welcome him to the panel discussion.
Let's kick off this session with a question to Justice Bhatt. Justice Bhatt, some of the high courts and subordinate courts in India have set up court-annexed mediations, which have led to institutional mediation at court level. And some of the success stories are amazing. What is the reason, according to you, that the court-annexed mediation centers are performing well as compared to the other centers?
First of all, I don't know whether this
It takes a couple of seconds
Yes.
to come on.
First of all, thank you for inviting me. It's wonderful to be back here. And it's the second time that I'm sitting in this auditorium in this building. If I could quote one of our former judges of the Supreme Court who went from here as a Chief Justice, it feels like Shah Jahan looking at the monument. I was on the building committee, I was a chair, but then it's a teamwork. I'm really delighted that it's shaped up so well. Now, apart from that aside, coming to the question, there could be various reasons perhaps. The first, and I would say the foremost, being that the ownership, and by ownership I mean the active participation and involvement of lawyers, perhaps drives a mediation center. So, in it, the first part is the introduction or the idea of mediation, which is to be floated proactively by the judges who wish to have a court-annexed mediation center. Having created that, I believe that wherever court-annexed mediations are run, and I don't mean that there's a very marginal participation, where there's a major participation in terms of day-to-day work, administrative work, assignment of mediation, allocation of work to mediators, and even running training courses, designing of those courses, etc. If this is done actively by lawyers or those who are going to be mediators, who have a direct stake in it, I believe that is one of the reasons for successes. And I speak entirely from my experience of the court-annexed center in Delhi, Samadhan. But I believe the same would apply with some degree of variation here and there. And secondly, as long as the judges or the judicial system plays a supportive role. Now, what is meant by support? Apart from initially setting up, it is important that some kind of let's say, an oversight, not even supervisory. You don't go back and say, these are my awards. That would be more hands-on, which is not needed. What you need actually is a very supportive role where the needs of the center in terms of infrastructure, in terms of funding, in terms of manpower, and all that is needed to run the center, because these centers are either part of the court complex or they are running because of the court. So unless the court is proactively involved in that, through a committee which comprises of judges as well as the mediators who are office bearers in that center and the bar, I think that's what is the recipe for success in these centers. And the third would also be, I believe, that every institution has to grow. And by growth, now we have some of these centers which have done very well, court annex mediation centers for the last 15, 16 years. And I believe that record keeping and an institutional memory of what has transpired, not in terms of every dispute, maybe having mediators' notes which are anonymized appropriately so that names are not known, and but then mapping out the success or failures, or let's say that too is wrong, mapping out the progress of a mediation, every mediation, the manner in which mediation assignments are made, if these are routinely documented, I think that would help in a long way, and that would contribute to the success of any court annexed mediation center. And the fourth thing, perhaps, which is also very, very important, is the continuous outreach. Now, one limitation which courts would have is the ability to reach out to members of the public, the litigants, etc. This is where a lawyer-owned mediation center, where lawyers drive it, scores. Because judges don't have to insert themselves into every program that lawyers run to outreach, to reach out to the people, to reach out to the litigants, etc. So judges have to educate and be proactive in ensuring that those disputes which should be referred are referred. That is from the courtroom point of view, and also supported. But as far as the mediation centers are concerned, if the lawyers are aware that it is important to reach out to others, which would include policymakers, litigants, and others, and the judges just step back and play a supportive role, I believe that's also one of the important ingredients. I think these 4 points would cover, according to me, success stories of those centers which are court annexed mediation centers.
Thank you, Justice Bhatt. Mr. Panchu, now I want to ask you a question. The topic of our discussion today is developing an institutional culture for effective mediations in courts. Could you please enlighten us as to what you think is the culture? What does culture in this context mean?
Thank you, Sudhanshu, and thank you for having me over for this panel. I think culture is both a broad and a mixed thing. I think it encompasses a state of mind, an attitude, and an approach, and behavior, ultimately translating to behavior. And I think it's interesting to see the way how this culture developed insofar as mediation is concerned. I mean, when we started, we were the outlier. We were really out of the pale. The question was, what is this all about? Why are we having this? Why should we be mediation? And then it's come more and more, into the frame. It's part of the legal landscape, but still, in a sense, a little peripheral. And now I think it's coming on to center stage, which is why perhaps the title for this conference is very appropriate. It's coming on to center stage for a variety of reasons. But I think it's important to recognize that part of it in the culture, that slowly this consensual method is now coming to be, closer and closer to center stage. and taking a rather harmonious seat with the adversarial system. The great thing about mediation is it's not in conflict with the other systems. So taking this, coming to center stage and taking this, harmonious seat. And culture, again, I think three short phrases capture the essence of mediation. I think the first is talk works. The second, I think, is we are settling for more. Conventional phrase is settle for less, but we're not, we're settling for more. And I think the third phrase is grey matters.
Sorry?
Grey matters. It's in the greys that you find the solutions, that you find the human emotions at work, you find the unstated coming to the mediator. It's the grey matters. I think these three things, to my mind, spell out a mediation culture. Institutional culture, I would say, to encourage mediation whenever possible as a first try. There are limitations, on pre-institutional mediation. We have to be careful, but to encourage it as soon as possible, whether before coming to court or after coming to court. To encourage it with ease and efficiency, we need to be careful about those two things. There must be ease, there must be efficiency. Court and expedition can't suffer on those counts. But to encourage, I think, also the reflexive question, I'm going to call it the reflexive question. Why aren't you mediating? Is, I think, the stage where we want to come to, where the judge says, why aren't you mediating this case? As a reflexive question. And I think even better than that, when lawyers and parties start to ask themselves this reflexive question, why aren't we mediating? That to me is, reaching that uppermost line of that culture. And I think one very important part of institutional culture and mediation court annex, we have to make it worth the while of mediators. I cannot stress this more than possible. We have to make it worth the while of mediators, because in that lies, a very, very important answer. It's. I think sometimes we think, they're doing good work, so maybe they don't need to get paid so much. I think that's they probably deserve to get paid all the more because they're doing good work. But I think that is a very important. And I have a feeling just about that some of the courts where perhaps it hasn't caught on is because they haven't paid attention to this factor.
Yeah, in fact, that's one of the follow-up questions that we have. We'll probably do that. Yeah, I think also that once you create that culture, like Justice Menon said in the morning, that people will think of mediation first and then litigation second. And not that how do you resolve it? Litigation comes to mind first. So you've got to think first about mediation.
Areas, because I speak from the perspective of lawyers and litigants from the Mofussil, from the district, who are not, who do not have this kind of good infrastructure you have. And so that to make it, if we have to make this really an effective and pan-India phenomenon. Now, first of all, I see that this is a lack of awareness which has been spoken by all the speakers, amongst the lawyers, the litigants, of the efficacy of mediation as a means of dispute resolution. Now, many lawyers are still skeptical of this process, of which we will be discussing, has been already discussed. The litigants are not even aware of what is this mediation, not to mention of the efficacy of this process. Therefore, I feel that first of all, spreading awareness amongst the lawyers and litigants is a very, very important step. We must. Then secondly, it is the apprehension of the lawyers of losing the professional staff and clients. This is a genuine fear among the lawyers, especially at this Mofussil level. See how many lawyers have these clients coming to him. And to let it go by resolving without much active participation is something, a fear that I am going to lose my income. This is a very big fear. Therefore, we have to impress upon the lawyers that, well, it may be the end of this dispute, but it's not going to end of litigation. We all know India as India as argumentative Indians. So these disputes, differences will keep on cropping up, but we'll be helping at least to resolve the existing dispute in a much more amicable and without losing too much of our time, energy, and cost. So these are important, which we have to make the lawyers aware. And of course, as a will discharge a very important social obligation, duty of lessening the burden of the judiciary, of which all the lawyers are aware of. Then thirdly, then there is a fear, there is apprehension that the lawyers may feel that it will show or demonstrate their inability to win the case. If it is resolved through mediation, then he may feel that the client may lose the confidence on him that perhaps he is not able to get things done through the court of law. That's why he is suggesting mediation. We have to impress upon the lawyers that yes, this is an opportunity to empathize with the clients of the problems and help them arrive at a fast solution and without again costing too much to the client. So these are things we have to make the lawyers aware. And fourthly, I would say that lawyers feel that, well, they are not really part of this process. I'm not talking of the mediator lawyers, the lawyers who are representing a client. He says he's reduced to a secondary role. As a lawyer, the client has come to me. I'm the one, I'm going to deal with his case. I must have a primary role in it. So the kind of relegating to a secondary role, something many lawyers are not very, very comfortable with. But we have to sensitize the lawyers, saying that, well, by doing this, you are respecting the autonomy of the parties to explore various other means of resolution of the dispute. And of course, sixthly, the lack of awareness among the litigants, which is very important, because the litigant, he comes, he's a problem, he goes to a lawyer, he reposes his trust that he's the one who is going to deliver. Now he's asked to go to a process. He's being mediated, which is the confusion which comes. Now mediated by some other person with whom he has not interacted. I mean, as a lawyer, we all know the lawyer-client relationship, the confidentiality, which he express everything to the lawyer. Does he do that with the mediator? Because he is not the one whom I have appointed. He is the one appointed by somebody else. So these are lurking fears and apprehensions in the mind of the litigants, also parties. So this is something which we have to, again, this is the role of the lawyers again, to tell him, well, don't worry, I'm behind you. What you are going through is something which will be beneficial to you. So these are something which continuous process of coordination between the lawyer and litigant is a key to the success, because we can't expect the litigants. We see litigants from the highly educated to the most kind of humble person. So we have to see all these aspects if we have to make this mediation a success. Yes, again, it has been spoken earlier also. The mediation process is not part of our lawyering skill. When we pass out from law schools, law colleges, and start our practicing, we are taught to win the case and try to get advantage, to the maximum advantage for my own client, and the kind of win for me, defeat for him. That kind of approach we take. Now, this entire thing goes for a change. So there is a change in the approach. The psychological training which we have already undergone and which continuously improve ourselves, there's a paradigm shift from that win-defeat situation to win-win situation. So these is also something which we have to be acquainted with. And of course, the last year I would say that so many wonderful success stories have been told, but law has not really incorporated. Perhaps there is a need of the time to more regularize more regulations, not regulations, but then codify these so that these are viable alternative process which perhaps has not yet taken. Therefore, we still don't know when we say mediation process, how do we undertake it? Of course, high courts have framed rules, but it is not really percolated down to the people. So we don't know that there's some element of ambiguity, there's an element of amorphous. Therefore, there has to be clarity that yes, it is a viable alternative means of dispute resolution. These are some of the ideas I thought.
Thank you, Justice Koteshwar. In the plenary session, Justice Kaul had raised an issue, concern, rather that sometimes lawyers would come and try and inform the court as to what transpired in mediation. and that the judges has to play a proactive role and say, we have to sort of very politely decline to sort of entertain that kind of an issue. Now, Justice Bhatt, do you think that these kind of issues, since they keep cropping up, it's necessary for the courts to be more educated, the judges to be more educated in the mediation process and in terms of referral of cases? Because experience sometimes shows that parties come to you and get the matter referred to mediation just to sort of avoid a hearing. And that is where a judge, if he is well trained, do you think if a training of a judge would help in sort of improving the mediation process? And also, what kind of an impact would institutionalizing mediation have on the court system?
Yeah, absolutely. I think judge education is a very essential component if mediation is to be a success story. Again, taking a cue from what Justice Koteshwar said, and I think it's slightly profound, although he laughed it off, it might have been a slip of the tongue, that meditation. But I do believe that when you are in mediation, one of the key components that is needed is that practicing the calm. Practicing the calm is a kind of meditation, which means that you unclutter your mind and cut out the noise. Now, this process is entirely different from, as everyone keeps emphasizing, the binary of a court adversarial system. We as lawyers, judges are seeped in that adversarial system where we tend to see everything in black and white. So, the process of unlearning, or rather a different learning, is necessary for mediation. Not just for mediators, not just for lawyers, but equally or perhaps more for judges, especially where judges are going to be referring disputes which are pending on their docket, or are likely to request parties to go into mediation. Unless the judge is sensitized about the process, and what is that process? It's not just an alternative to dispute. I mean, it's not just a supplementary or an adjunct poor cousin of litigation. Every dispute has seeds of breakdown of relationships, breakdown of communication. So if the judge, like the lawyer and the mediator, understands that this is a process where, and it is not going to be an easy one, where if parties were able to re-establish communication, there would be no need for even a court, much less a mediation. So once one understands that this is a process which is to kind of remove the dust from their relationship and restore that element of confidence in each other, it is going to take some time, number one. So there are certain basic ground rules which judges should be aware of. What are capable of being mediated? Which is, you should have that skill to, and you just can't compel people to reach out and say that please go into mediation. There could be stages in which mediation could be most appropriate, maybe not in the beginning, but during the course of the litigation, when parties have sufficiently fought each other, they've kind of, as they say in Hindi, pak gaya. So when you reach that stage of, you are getting fed up of each other and the litigation process, they're perhaps right. There is another type of litigation where you want them to go in the beginning. And there is yet another stage where you could perhaps ask people to go in for mediation, partly mediate a settlement, and then decide the rest. Like in arbitration, you have med ab, etc. This is the second point. And the third point, which is extremely important, and I think that is one of the important takeoff from what you said, when lawyers come and start talking about what transpired in the mediation process. I think that's a dark spot on which light should never be shed. I am of the opinion, and I believe that's one of the basic tenets of mediation, that what transpired in the mediation should not be shared in the court, because the idea of mediation and the confidentiality of the process is the parties are assured that what we say to the mediator and what we say to each other, or what the mediator shares with each other, will not be let out at all. Therefore, they may be very candid and frank about stating their positions. Now, if that is let out of the cat is let out of the bag, as it were, I think that actually undermines the entire confidence of the litigants in the system. So each time this is done and each time it is shared with the court, I think we are undermining the system. And a judge who encourages this, I would not use strong words, but needs to revisit his training. So it is important that the judges have to be invested in this idea of mediation and what are its benefits, because there is no binary here. And though the process may take sometimes longer than you actually visualize, but at the end of the day, you have sniffed the entire litigation in the bud, sniffed it out in the bud. Therefore, there is no appeal, there is no further appeal to the division bench, and then there is no further special leave petition, and years of litigation, layers of litigation are cut out. Therefore, if you do spend that extra bit of time, and this is where, just to take off from Justice Koteshwar's, lawyers have this problem of referring matters to mediation because it might be seen as a weak point, or that they are not aggressive enough. But that's not the case in mediation. You may not work, it may not work the first time, the second time you may still go back to the table and start negotiating. You can negotiate any number of times. So if the judge understands this, I think, and plays a supportive role, much can be achieved.
Because like you said that at the time of reference, the judges need to sort of prepare the parties for mediation. And then when it comes back unsettled, at times the judges can play a proactive role in bridging the gap and bringing about a settlement.
You're right, but I believe that bridging the gap too has to be a voluntary process.
Right.
It cannot be, very ham-handed, and you can't impose a solution.
That's right.
Now, how much of a mediator are you as a judge would depend. Maybe you are a trained mediator. Now, how would you conduct the process would entirely differ from me. I might be more of an aggressive decision maker. So I think that is very important for the judge to be aware that there is a point at which you have to let go, and there are different points at which you may have to balance it out. So this awareness is very essential, and some kind of a program and a continuing program is necessary. So I believe the National Judicial Academy, even the state academies have courses, refresher courses on how to refer matters to mediation and what mediation can do. Perhaps we would do well as High Court judges to also get involved in all this.
That's right.
Yes. Mr. Panchu, you've had such a vast experience of training so many mediators, conducting hundreds and thousands of mediations. Do you really feel that mediation really has reduced or reduces delay and costs and actually improves access to justice, more particularly in resulting in a higher quality settlement? Does it really work like that?
Without doubt, but in the appropriate kind of cases.
Yes.
You can't universalize this. In the appropriate kind of case, and that's a question of wise discrimination, where mediation is applied, it can dramatically reduce the time and the cost. It'll get you a practical solution, which is what people want.
Mm-hmm.
There's focus on the present and the future rather than the past.
Mm-hmm.
It's participatory. People actually, the litigants engage in it. And it can really repair relationships.
Mm-hmm.
And frankly, for all the talk on enforceability, if there is ever a question about a mediation agreement is the most easily enforceable thing, but let me tell you one thing. 99% of mediation cases never require enforcement. I have mediated for 30 years. I haven't had a single case in which a party has gone to court and said, I want to enforce this. They don't have to because, they reach for something which they both think is in their interests. So it ticks off all the boxes. Actually, Justice Suresh Menon has a lovely phrase, which I have cited quite often in my writings. He has a phrase, he says, what's not to like about mediation? And it's a classic question. What's not to like about it? And taking off what Justice Call said, out of the box and innovation in solutions. For good mediators, experienced mediators, actually out of the box is normal. And innovation in solution is the name of the game. And that's why I think Sikri Saab, this idea of we should actually write some of these things. Because when you come to those magical moments, when parties have started to come out with their options for settlement, which is really the magic moment. And you've crossed the line, you've crossed that 50% line. But I think there are some cautions to mediators. I think just because we are in the court process, we can tend to take things a little slow as far as time is concerned. And we should not, lose the moment when it comes. That's one thing. I have one view on costs, which I want to share in this gathering. I think we should make parties pay, especially when they have succeeded in the mediation and the benefits are substantial. There is a case, and I think also asking parties right from the beginning to pay some amount, which makes them also a little more serious for the mediation. But we have settlements which run into crores and some hundreds of crores sometimes. And we just don't know, we have not developed a method of getting parties to pay, and I'm telling you, they will be most willing to pay. The first big case that we settled, Standard Motors, it was 50 crores in 2005, 2006. And the banks came to me the next morning after the settlement, and they said, we've got 30 crores in this, and how much do we pay? And I said, we don't have a system, for charging. Just if you want, we need a water cooler, you can buy us a water cooler. So they bought the water cooler and they gave us a check for 30 lakhs, which we deposited in the mediation center's account. But I think we should have a system of making people, pay, especially in the successful cases where the magnitude is large. And I'm telling you, parties will be most willing to pay because they've got the benefit, they've saved themselves years of litigation, they've got a good benefit, they'll be willing to pay. So I think that is one thing we should do in our court system. And there is another big point I want to make. You tell me when to make it and I'll make it.
Okay. No, in fact, I'm quite in agreement with you because I've also done so many high-valued commercial cases where parties have offered after a settlement they'd like to pay, and we say the same thing that we don't take any money. You'd like to donate it to the center, you're most welcome to do it. Some of the parties have, and some of them just talked and then didn't do it. Now, Justice Koteshwar, taking the cue from there, because I think what is important is to encourage good lawyers to come forward and become mediators. It's very, very essential to get high-quality mediation process and high-quality settlements. It's important. So, just like Mr. Panchu said, that we need to get the parties to pay. Do you think, in the context of the courts that you work for and the states in which you have jurisdiction, will the parties be willing to pay to the lawyers, good lawyers, so the lawyers are encouraged to come and become mediators?
That is, I think, regarding payment, that is something which is required to be discussed and deliberated much more intensively, because payment of fees to lawyers is something, as we know, the number of, I think PI also filed that the Bar Council or the state should provide monthly remuneration, some kind of fee stipends for the lawyers. So
that's right.
Yes.
The point is that remuneration is very, very nominal.
Nominal, yes.
So to encourage good lawyers to come forward, because they devote a lot of time and energy into it.
Perhaps the state has to get involved. I mean, I feel that because the state is the only agency perhaps in this, apart from other various NGOs, companies, just like how NALSA is being also run. The state is not only the source of finance, because we have to reach out to other organizations, companies, industrialists, doing a lot of pro bono, donations. So this is something we have to look at. We see mediation. I always see from the perspective of this lawyer in the Mofussil. I see they are very good lawyers, but they have not seen the high courts, they have not seen the Supreme Courts. But they are doing wonderful works, and this has to percolate down to them also to make this mediation a reality in India. In which event, how do we deal with this situation? And this is something which has been I don't have a ready answer for that, how to make this viable for the lawyers who are struggling to survive. In the process, also make a mediation a part of that this dispute resolution. As I always feel that the legal service authorities have to chip in, then the various organizations, the state has to chip in, the bar council has to chip in. How to make this kind of attractive for lawyers, because you can't expect the clients to settle with two kinds of fees. To the lawyer he has engaged, and again for the mediation process, which amounts to some kind of a imposing court fees or something like that. Okay, you have gone through this mediation process, therefore you have to pay another fees. So that kind of acts as a disincentive to the litigants also. So this is some area which perhaps would require a broader consultation with all the stakeholders. This is what I feel.
Thank you.
You see, again, since we are looking at the bill, for example, the court fees that is paid is not commensurate to the kind of expense that actually is undertaken by the government or the court in that. And the lawyer's fees is actually not comparable to the court fees. So probably the government, when it's looking at the bill, should also consider encouraging the lawyers in coming forward. A good lawyer certainly if you have to draw a good lawyer from his practice into mediation, it would be something like a pro bono work, which they do as amicus, and sometimes they do assist court. So this may require some kind of a deeper thought. As Justice Koteshwar said, it will require a lot of deliberation. Justice Koteshwar, sometimes we feel that once the cases are referred to mediation, then they're really out of the court system, because the judges would then like to stay their hands. Like you are in mediation, and parties at times spend some time in mediation, and it is at times required to give that kind of time, because parties are litigating for several decades and suddenly they come up and they're placed on a platform where they need to discuss. So it might at times takes time. Do you think there is a supervisory role that the referral judge continues to play or should play during the pendency of the mediation process?
I feel so. Though once the matter is referred to mediation, the normally court loses control over the actual mediation process unless it is referred back as unsettled. But the courts have to realize that the entire process is again started from it. Therefore, the court should have a broad kind of not supervisory or some kind of monitoring, something what is happening, so that, because the idea of mediation is to not only to save money but also save time. Now, if the mediation goes on forever without any end in sight in near future, it is a matter of concern for the court to which has met the reference. Therefore, I feel we must work out some kind of mechanism to ensure that the mediation is going smoothly and also timely. This is something we have to work out how it has to be worked out. I'm sure with the shared experience of various courts in this, we can find out a kind of modality. And of course, there may be stages where mediators also need to discuss with the witnesses or some other parties. Then sending summons and all these processes, I think the court can chip in. So that the mediators, obviously, he said, well, how do I send someone to this gentleman whom I want to again have a word with is important. The court has to have some kind of, not a very detached, but a kind of broad kind of idea of what's happening in the mediation. The court can always help render this kind of assistance. I feel that will be therefore I feel that respecting the autonomy of the mediation process is going on, the court should have a very broad kind of idea what is happening, kind of bird's eye view, and wherever is needed, I think that will be, I think, my ideal situation for a judge.
Thank you. We're short of time, so we'll quickly run through a couple of more questions we have. We've already sort of, I think, spilled over our scheduled time. Justice Bhatt is now moving away from courts. Do you think that, does your Lordship think that should private institutions be set up for conducting mediations? And if so, should professionals other than lawyers be also trained as mediators?
if you go back to the core of what is mediation, which is that it is restorative of relationships which are broken down. I don't think lawyers or judges have a monopoly over that. On the contrary, judges play a role as decision makers where the actual the breakdown reaches them. And lawyers facilitate that in the sense that there is aggressive posturing on both sides. So mediation is entirely different. So even the lawyer who's trained as a mediator has a different mindset. He unlearns his legal skills
Yes.
and compartmentalizes them when he becomes a mediator, and so on and so forth. If that is the case, I don't believe that the legal system or the judges or lawyers have a monopoly.
Correct.
We could have any number of kinds of people who could be good mediators. Basically, what do you need? Your certain basic skills are essential and common. Listening skills, the ability to draw out people, the ability to nudge them towards solutions which will come out from within.
Yeah.
Now, I don't think we can be so arrogant as to claim that we only have that capacity. Basically, when someone says, I'm willing for this, or rather you're dusting off those problems, you're asking him to go into his or her own heart and find that solution. So which is not confined, which is not a skill that is confined to lawyers or judges. Yes, we have been pioneers, so we can claim that credit. But to say that we should occupy that space entirely would be also a conceit. Therefore, I feel that the more, and secondly, what we see today is a treatment of a kind, a curative. But mediation is not just that. If mediation also is preventive in the sense that it has to reach out to those places which are beyond the courts. It could be large organizations, it could be workplaces, it could be universities, and it could be a lot of other areas where conflicts are brewing. So if those conflicts are brewing, people trained in mediation in those places, and there's nothing wrong even if lawyers are also brought in and trained mediators go in there. If they play a role, whoever they are, I think you are doing a greater service than when the matter reaches the courts or reaches the lawyers. So I think the movement, as we call it, has to be widespread one.
Yes.
And therefore, naturally, you have to encourage, or rather, you have to look at a scene where there are more private mediators, there are private mediation centers. And I do believe that although there is a bill and then there's a lot of debate on this, there has been consultation, there's been a report, a parliamentary report, etc. I believe, and I think what Mr. Panchu said, that over-regulation is bad. And I'm always reminded of one area where in education there was no regulation. And today we are I think $1 billion or whatever, our prosperity has come because of that. There was no computer education in the universities. It was private universities, private institutions which actually gave that, and that led to creation of all these software experts. You had hardware engineers, but the creation of computer engineering was not in schools, it was not in colleges. It became more widespread much later, and when the 2K happened, the millennium, those experts and software people, they were poised to take over, and I believe so. Likewise here, over-regulation of mediation would actually stifle it. And over-institutionalization, especially when you say that courts or lawyers alone should have it. Sure, they will have enough space in it because being pioneers and being also aware as experts, when you draw up settlements, you do need lawyers or trained mediator. But to say that we should only do it would not be correct.
Thank you. Mr. Panchu, taking that, sorry. Yes, please.
The index of conflict that we have available with us is of pending cases in the courts. These pending cases are brought to the courts through the medium of advocates. Everyone is represented some way or the other through an advocate. Now, when advocate is the medium and he provides us with the index of this conflict in the society, it is from these advocates that we demarcate a set of work for mediation, subject to their consent, and we pay them. Now, suppose if we make for anybody in the public that he is free to persuade a person for resolution of his dispute through mediation, but he is not a mediator, will we have to evolve a payment mechanism at par with that of a mediator for that person also, so that the program is more sensitized and it becomes more public driven? Can it be? Secondly, our mediation centers, wherever they are operating, either the state is the financer or the mediation centers generate money of their own from the parties. Wherever parties pay, a little bit of it goes to the party, one of the parties in matrimonial matters, and some of it goes to the mediation center. So, is it the idea that for larger public participation, we should have a payment process for those outside people who are not the recognized mediators? Is that the suggestion?
Sir, Justice Bhatt would like to take that.
Mrs. Masudi, I think, let me make myself clear. I'm not talking only of court mediation. I'm talking of possible places of conflict. Number one, even in disputes which hit the courts, it is not needed that you will have only lawyers. You could have others as well who could help the parties in resolving their disputes. And disputes can be anywhere. What is important is regulating what kind of mediation training is necessary. I think that's the bare minimum that a law or a set of regulations can provide. And I believe that is one of the important components of the bill which is coming. And the bill, as I see it, doesn't confine mediation to lawyers alone, which means that ultimately what Mr. Panchu said also, there should be private mediation, there should be private mediation practice, there should be private institutions. Now, if we don't allow that, or rather we can't live with that, we tend to see everything as an alternative to we say it doesn't become an alternative, just plays a supplementary role. Mediation is not meant only to unclog the court dockets. Wherever there are, as a society, we know mediation happens. We don't use that word. Negotiation happens. Settlements take place. Do all lawyers always play a part in that? Not necessarily. So therefore, this is a scientific and a method by which people are trained to do it. And there are some professionals
Goes there and settles it, even it hasn't seen the day, not reached the court, pre-litigation. Every day I can say that the PLVs are doing wonderful work, doing the work of mediation, and they're being paid what? No. Just one day they are getting 500 rupees, but they have settled potentially a kind of high, potentially kind of confrontational litigation has been resolved at that stage. Just for 500 rupees he gets and he resolved this. So it's mediation also taking place. Many people are not aware of this. The paralegal volunteers are doing a wonderful thing in the field.
Yeah.
Thank you.
This is the last
Justice
question. I'll leave it to you.
As a last question and a guidance to all of us, as well as the other judges and chief justices who are here from other states, what would you suggest system that we adopt in making the court-annexed mediation more effective?
Only two steps. I think all judges should be aware and open to mediation training. I'll confess, if I'll be the first one, I am not mediation trained. I have not attended any program, but that is a shortcoming which I am intensely aware of. And I believe that all judges at all levels, especially at High Court level, should be open to the idea and receptive to go in for mediation training, number one. And number two, you should have that horse sense, as they call it, of saying which is capable of going for mediation. And at the same time, in mediation, if we are aware that dockets are clogged, we should not look at mediation as a parallel court process which is there to unclog it. If the object of mediation is to bring parties together, we should not really be as bothered about outcomes, that we have sent 100 and only 15 have come back settled. So for those 15, it's a 100% settlement. So we should not look at those outcomes the way we look at our institutional clearance ratio, because mediation is a different process. And if there is a different process where we emphasize on autonomy and choice and restoration of relationships, that you are able to not fully do it, but maybe you have done it 80%, you have sown the seeds. Therefore, this awareness is far more important, especially for judges, when you send mediations, and don't give up on mediation just because some disputes come back unresolved. Because there could be times when the same disputes go back and come back to you fully resolved. So don't give up on mediation. It is important that all of us are invested in this all the time.
We've had instances where matters come back unsettled, and they go back, and the parties then realize and come back together, and within seconds it settles. And we were informed in the last session, Justice Kaul has himself attended about 17 sessions. So I think we'll have to bring a close down to
Because
this.
you don't get the
Can I
eureka.
just make one
Yes,
point,
yes.
just one point, because I think this is a big ticket point. And let me put out a proposition. May sound a little provocative, but I think whether we are going to move from the bronze and copper and the iron to the golden age is going to depend on one thing. Are we encouraging the growth of professional mediation as a career option for people?
Absolutely.
I think that is the single most important thing.
Absolutely.
Outside the court annex system, whether it's in sector specific or grassroots, at panchayat level, or an Indian mediation service, or just private professional mediation as a career, that really is going to be the determinative test.
Absolutely, absolutely. 100%. I think that is well taken, and that should be the takeaway from today's second session of our discussion. Yeah, Mr. Please.
So with this, ladies and gentlemen, we conclude our second session, Developing an Institutional Culture for Effective Mediation in Courts. We are grateful to Honorable Judge, Supreme Court of India, Mr. Justice S. Ravindra Bhatt, Honorable Mr. Justice N. Koteshwar Singh, Chief Justice, Jammu Kashmir and Ladakh High Court, and Shri Sriram Panchu ji, Senior Advocate and Mediator, as our panelists. With a huge round of applause, let's express our gratitude to the panelists and also to the moderators, Mr. Justice Sanjeev Sachdeva, Judge, Delhi High Court, and Member Overseeing Committee Samadhan, and Sudhanshu Batra ji, Senior Advocate. Thank you very much for joining us, and now we will disperse for the lunch. We will try to cut short the time for the lunch because we are already delayed. So I request all of you to be here around 2:15, possibly. We have half an hour time for the lunch. Thank you very much for your presence, ladies and gentlemen, and please join us for lunch.
Thank you. Your inputs.